Hello, my name is Jubin, and in this video we're going to talk specifically about office actions. These are communications from the Patent Office or the Trademark Office, wherein your application that you filed has been examined and they're now communicating with you whether or not you can get a patent or a trademark registration. So what is an office action, and what's the difference between a first office action and a final office action? So let's start with the office action in general. What is it? What is the information being communicated, and how do you digest it so that you can respond appropriately? So if an office action is when the patent office, let's assume it's the patent, looks at your application, specifically looks at the claim language of your application, and based on that determines whether or not you can have a patent granted. Now they will search, analyze your claim language, and then write a response to you. Now, if the first office action says you can have your application allowed, in other words, they say you have allowable subject matter and you can go to get your patent granted, that's great. However, I really would suggest that if you get a first action that says you have allowable subject matter, that you look further into your case to see if your claims are too narrow. In other words, what can you do to broaden your claims, to force the patent office to find references and actually give you a rejection so you can better focus your claims. Now, if your first office action is an actual rejection of your claims, it's not a big deal. You take a look at the rejection and the reason they've cited. They'll give you references. They'll give you reasons. They'll basically lay it out for you as to why you can't have a patent granted based on the claim language that you currently have. You then can go and do a couple of things after the first office action. You can do a response, a written response right away. You will be given 3 months to do that, which also can be extended up to 3 more months. So a total of 6 months can be used to respond to an office action. If you do extend it, you have to pay additional fees. Each month extension has a fee associated with it, and they get more and more expensive the more you take. So if you take a 1 month or a 2 month or a 3 month extension, then you have to pay for those accordingly. Now, back to the office action. Once you prepare your response, you have a couple of options. Like I said, you can do a written response right away and respond to the office action. You can also call and set up an interview with the examiner to discuss your case, which I highly recommend. Which allows you to better understand how the examiner is reading your claim language and interpreting it without having to put a lot of things in writing. Remember, the more you put in writing, the easier it is for defense attorneys, once your patent issues, to use the language that you used against you. Your third option is to not respond at all and let the case go abandoned. If you don't respond, the case will become abandoned and your application is no longer an active application. Now, once you respond to the first office action, then the patent office will look at your response, further examine your case, especially if you make changes to your claim language. If you just made arguments, then they look at your arguments to see if it's persuasive. If you have made claim language changes and arguments, they'll look at both and then respond to you. Now, they have the option at that point of giving you another non-final office action, or they can at that point give you a final office action. Typically that's what happens because examiners are under extreme time pressures. They will issue a final office action after the non-final office action. They won't want to go to a second or a third office action beyond the non-final. And the reason for that is, again, they're under extreme time pressures, so they will typically go to a final office action. Now, once you get the final office action, you have a couple of options after that. You can, like I said earlier, do nothing and let the case go abandoned. Typically, they'll give you a 3-month window in which to respond to a final office action. However, if you respond within 2 months, you have the advantage of them having to respond back to you to give you additional time. So, you have the final office action. You chose to do nothing, the case went abandoned. The alternative to that is you can choose to prepare a response and file it. Now remember, a response after final doesn't have to be considered by the examiner. So if you file a response and the examiner doesn't consider it, your case will go abandoned. Your third option is to file a response and ask for them to do it under a certified pilot program to give them a chance to come back to you and discuss the case with you further. However, again, they don't have to consider your response after final or any changes you made after final. They can simply let it go and your case will also become abandoned. And of course, the alternative to all of that is to file a request for continued examination, which has fees associated with it, but it causes the examiner's clock to be reset, in which case they will issue you a non-final office action again. So you can file a request for continued examination, get another non-final office action. Typically though, if you're working with a patent attorney, within 1 or 2 office actions, they should be able to resolve the situation in the case. However, sometimes it doesn't work out that way. Sometimes examiners go find new references or things that come across their desk that they didn't know about before. And as a result of that, they'll issue you a final office action, or you won't be able to come to a term or agreement. So summing everything up, office actions are communications from the patent office or the trademark office in which they tell you after examining your case what the problems may be with your case. The office actions are typically non-final or final. And once you get either one of those two, you can respond to them. You can do nothing and let the case go abandoned. And in the case of a non-final, you can do an interview with the examiner. In the case of a final, you can file a request for continued examination. That's it for now. If you have any questions, give us a call. Help us out. Like and subscribe to our channel. This is our information here, or I should say here. And thank you.